The broadcast is now starting. All attendees are in listen-only mode.
Well, good morning, good afternoon, everybody, wherever you are. Mike Volkov here, and we're going to talk about sanctions enforcement and compliance for 2024. Thanks for joining me. Um, I also have uploaded the slides, if you can get them. I know that some people get frustrated um, by by the fact that there's firewalls or whatever that make it difficult to download. So if you want a set of the slides, I'm happy to go after to send those to you. Just afterwards, send me an email at mvolkov@volkovlaw.com there on the first page, and I'll be happy to send you a set of the slides. We also will post this on our YouTube compliance channel, and we have about 120, 130 recordings from all through the years, believe it or not. So anyway, it's great to see everybody. Hope everybody's doing well. Happy New Year again. I know Larry David says you're not allowed to say that after the first 10 days. But let's look at this issue, and hopefully we can. I want to get people really focused on this because I think this is going to be the hot issue with the new administration. It's going to be trade, tariffs, sanctions, export controls, and it's going to get more and more complex, I think, and there's going to be a lot of enforcement as they're sort of primed to do so as well. So it's an increasing risk. DOJ enforcement increased this year, but we didn't see any of the big corporate cases like last year with British American Tobacco. Um, they are still, I think, in the process of ramping up and going after some of the companies. OFAC, interestingly, had a slow year, and I think it was a lot of work on the Russia sanctions and a lot of you know, sort of coordination with Europe, other countries, other areas as well. Two compliance areas that come out of the trends here of the enforcement trends. One, mergers and acquisitions. And by that, I mean integrating your acquired company. You'll see some cases where OFAC cites the fact that the acquired companies uh, were not integrated into the parent company that bought them, and what you see is a failure to recognize that the company itself was engaged in conduct that was violating OFAC sanctions or would in the future. And so take a look at that. Please be mindful of mergers and acquisitions. That's a big, big risk these days. And a successor liability means you're buying a set of OFAC violations when you buy a company that has engaged in violations already. The other big trend is OFAC is really out there stretching its jurisdiction not only to secondary sanctions, but you're going to see a couple cases where a foreign company caused an American company to violate sanctions. And they then are brought in, and jurisdiction can be asserted. And you'll see a couple cases like that. Overall, my message is enhance your trade compliance program, conduct training. Remember, there's an annual training requirement by OFAC. And we all have sexual harassment training that's required by various states. Add to your list OFAC sanctions training. So we can help you with that if you want. Just a reminder on some of the global sanction schemes. Venezuela is back on the list with, their 6 month period didn't go so well, where they relaxed in the hope of getting fair elections. The Russia program obviously is just absolutely, comprehensive and creates a lot of risks. And we see some of our old favorites with North Korea and Iran. Remember the types of regulatory schemes, because you're going to see some of these invoked in some of the enforcement actions. They're countrywide. There are selective, which means SDNs, or in the commerce situation, is on the designated entity list, and they're purpose-based. There as well as we still have sector-based and the old Russian sanctions from 2014, and we had an enforcement action relating to that as well. The only new development, I think, in the Russia sanctions area is the administration yesterday left a parting shot of a final round that was comprehensive against the Russian energy industry. If you're implicated in vessels and whatnot and shadow fleets, so please take a look at those, because those had a big impact with these new energy issues, energy designations. So when I say OFAC had a slow year, it had a slow year. Look at this. They only had 12 enforcement actions, way down from 2023, way down from 2019, way down from 11 years ago. These are the numbers, and the only explanation I can come up with is that they had resources pulled into other areas. So this is something, I don't think it's going to be this low this time as well. OFAC total fines to 2024, you can see is pretty low. It's only in the 47 million is all that happened. And look at that in comparison to 2023. They didn't have any blockbuster cases this year, like they had Binance last year and other ones. And no major bank prosecutions, foreign bank prosecutions, although I think we'll start to see more of those given extra resources being given to that. Remember DOJ and sanctions enforcement, because here they come. Criminal trade prosecutions, they're renewed warnings. We saw the case a year ago in 2023, British American Tobacco, which was for over 600 million. We're going to see these, trust me. They're in the works. I actually think Seagate may be the first case. Seagate was an administrative fine of 300 million imposed by BIS in 2023. And if I were DOJ, that's the first case I'd bring in and prosecute. Anyways, so these are what DOJ calls the new FCPA. Two new reasons that I always highlight this. One, 25 new prosecutors have been assigned or in the process thereof to the National Security Division for sanctions and export control violations. And I used to work at DOJ, and they'd have maybe two people who were concentrated on that, and then they would work with certain U.S. attorneys' offices. And now, when you have 25, this is going to be big. Further, they invested in slots in the Banking Integrity Unit, which is part of the anti-money laundering section in the criminal division, and for investigating global banks for sanctions violations. So we're going to see some more of that. But here's proof right now of at least where they're starting. A record year for DOJ in terms of the number of indictments brought. And these are indictments for sanctions cases, export controls cases, and ITAR actions. And all of a sudden, you're up to 70. And I think this number is going to keep going up and up and up. What I've noticed is lots of individual cases, individuals who try to, export things to Russia, to Iran. They're getting caught, they're getting prosecuted, and the cases are going up because of the higher priority. Now, those could lead, depending on the company they work at, to corporate prosecutions, but I still think we're going to see some corporate prosecutions on their own, and then individual cases after that. And here's some interesting I broke down all of these cases to look at what countries was the focus of the enforcement. And interestingly, I was surprised to see that Iran is still the major focus with 25 cases. Russia was second with about 22. Venezuela was third with about 10. And then down to China and Sudan, equal, and then Iraq, Colombia, and North Korea. And Iraq and Colombia were prosecuted because of SDNs who were located in Iraq and in Colombia. North Korea is even lower than that. So, in any event, and I'm surprised that North Korea is so low, to be honest with you. What will we see next year? I think here's where, and we're going to, at the end of this, I have a little section to talk about the new administration and what are some of the risks. But I think number one, Iran is going to continue to be a high number of prosecuted cases. And I think we're going to see China. We're going to see China raised up, particularly as they tighten export controls, as we ramp up in sort of controls over AI, chips, intelligence. We're going to see more and more prosecutions for China exports. Russia will probably continue as well, just as remnants, but we're going to talk about the Russia sanctions and what I expect to happen in the next year or two. But kind of curious, Iran is still there and is still a major focus. And if anything, Iran is going to become even more of a focus in this next administration. Just a reminder, if you get into a situation where you are going to do a voluntary disclosure with OFAC, remember that there are now two possible ways, two ways that you have to clear yourself. The voluntary self-disclosure is obviously a big mitigating factor with OFAC, and that'll cut your penalties right away in half. And it reduces your maximum fine by 50%. The problem is now that you have to get a sense of the facts and decide whether or not to disclose to DOJ. And because the company that voluntarily self-discloses, cooperates, and remediates, all of a sudden is in this situation because they can then be prosecuted. You could have a deferred prosecution agreement, non-prosecution agreement, but basically your self-disclosure is going to earn you a big fine reduction up to even actually 75% and no corporate monitor as well. So remember that. Now, what's the difference in the standard in terms of OFAC as a civil enforcement agency, DOJ, we're talking about criminal cases. The standard difference is willful. If you or your company engaged in prohibited transactions, you're on the hook with OFAC, whether or not you thought it was illegal or not. But with regard to DOJ, if you have evidence that involves potential willful conduct, if done with knowledge that the conduct is illegal or may be illegal, they don't have to know the specific law or regulation, but then you're in front of DOJ. So you should do a simultaneous voluntary disclosure to OFAC and the DOJ to get the full benefits of it. But if you don't have any willful evidence, any indication of willfulness, then leave DOJ out. Okay, let's talk about some of the cases. And we had 12, as I mentioned, 12 OFAC cases in 2024. These are a summary of listing of them. Many, many interesting issues came up in these, and I'll point them out. I'm not going to go, you'll see the slides are kind of text heavy, and I don't read slides, but I'm going to try to point out some of the most salient points so that you can get a feel for the cases that are brought and sort of where they are right now with regard to cases. Again, remember my major points here are merger and acquisitions and integration of the new company, Number two, we had individuals who were prosecuted, including one for $1.1 million, largest individual penalty I've seen, but two individuals prosecuted, thereby demonstrating OFAC is now saying we will go after individuals when appropriate. And we have various foreign companies that were brought into US jurisdiction by the fact that they caused an American company to commit a violation. So Vietnam Beverage being one, and EFG International, I think, or I can't remember if it's SCG Plastics or EFG International, because that's a securities case. Okay, so let's take a look at some of these. Here, EFG International was the first case of the year in 2024, and it involved a Swiss private bank for $3.7 million. And this was a reminder again for the finance industry and securities companies to be really careful no matter where you're located. And I think if one thing, another risk factor, if there are US dollars involved, you've got to comply. Even if you're overseas, everything happens overseas, but there is some kind of correspondent banking transaction that involves US dollars. Boom, you are there. So this is obviously a Swiss private bank, and for over a 4-year period, they did all these security. They did a high number of securities related transactions for Cuban customers and an individual who was blocked under the Kingpin Act. That's one of your purpose driven or individual driven, and 5 payments for a person who was blocked by the Russia sanctions program. They voluntarily disclosed, and then they got credit for their remedial measures. One new thing that I hadn't seen very much was suspension of a completion of certain compliance commitments, and that being $1 million, pending satisfactory completion of certain compliance commitments. So in other words, they suspended $1 million of that. So the remediation involved an internal control to require compliance approval for any high-risk counterparty, improving coordination and notification requirements, RAY SDN customers, and focusing on high-risk countries and applying enhanced due diligence. And then an annual sanctions risk assessment as well. So EFG did a lot of remediation, and by that, they were able to get this as well. I got a comment here which says to me, "What is your comment on a Balkan sanctions enforcement?" Miss Anna Morris came to BIH and said that banks are at risk of secondary sanctions if they continue to have OFAC designated persons as clients, which has led to the closure of their bank accounts. Companies are automatically liquidated because they cannot operate without a bank account, and individuals cannot receive their salaries. Banks and BIH in the Balkans decided to close accounts in order to avoid that. That's a great point, and I will tell you, secondary sanctions has been stretched unbelievably under the Russia sanctions program, obviously to any financial institution that processes or supports Russian businesses. As a result, OFAC's more comfortable now with using and the State Department with using their secondary sanctions authority. So that is a big, big deal and a big trend as well. Thanks for the comment, though. That's a good comment. The biggest case of the year was the second case of the year, where SCG Plastics had to pay $20 million. And this, to me, again, is OFAC stretching its enforcement arm. Foreign companies that cause, in quotes, cause U.S. financial institutions to process prohibited transactions, all of a sudden are subject to U.S. sanctions enforcement. So $291 million in wire transfer sales of a resin that's used in a lot of plastics and other things, manufactured by a joint venture in Iran owned by SCG's parent and an Iranian company, a prohibited government company, state-owned National Petrochemical Company of Iran. They received wire payments for this Iranian origin product, and they made US dollar transactions. And they obfuscated or attempted to obfuscate the product's Iran origin and the parties involved. And the US financial institutions ended up processing these wire transfers. They also transshipped the resin product and resold to its customers through the UAE. As I've always said, the UAE is the transshipment point in and out of Iran. It's a high risk geography, and there are lots of trading companies in Dubai, which are often used to facilitate these illegal transactions. So 467 violations, $20 million settlement. One of the remedial steps is the plastics company shut down its business. And as part of this, the parent company agreed to maintain US sanctions compliance commitments for 5 years, even though the offending company is gone. And you can see here sort of the remedial measures that they took. Well, here we stretched into animation and cartoons into North Korea. And for $538,000, Mondo TV, which is an Italian animation company, outsourced a project to North Korean animation company. And the US jurisdiction, again, was based on US dollar transactions. And the North Korean invoices substituted third parties and their US bank account details as a way to circumvent the bank's concerns or bank blockage of these wire transfers. Now, interestingly, the evidence to me showed, and this was interesting, and who knows if DOJ is even looking at this, but Mondo TV understood it was paying a North Korean company. The CEO of Mondo TV approved and signed the agreement, which specifically referred to North Korea. And then emails and related documents referenced payments to North Korea and Mondo TV's chief operating officer and the chief legal officer approving the payments. Pretty, I mean, not even flagging it, but approving the payments. Interesting. Well, then we got to our Russian sectoral sanctions violations. Remember the sectoral sanctions in 2014, and there were certain directives. There were 4 directives, one of which placed a limitation on the timing for new debt. And State Street Bank, and this also underscores the danger of an acquisition. State Street Bank bought a set of violations by purchasing Charles River, a fintech subsidiary that had engaged in violations of the sanctions and continued to do so 2 years after the acquisition. State Street's due diligence and integration process was called out as a failure here, and State Street paid $7.45 million after buying basically 38 violations. And they inherited these violations. And so the due diligence and integration audit would have uncovered problematic transactions if it had been done and been done carefully. So what happened, and remember that there were temporal limitations on the new debt under the first directive. And at first, for a certain time period, it was 90 days, then it went down to 30 days, and then ultimately to 14 days. And Charles River ended up circumventing the sanctions by having the 2 entities, VTB Bank and Sberbank, redate the invoices to meet timing restrictions. In other words, they sent them the invoices, said, make it look like we're paying you within 30 days. and for that reason, they got dinged in connection with this. So this again shows you acquisition, acquisition dangers, acquisition dangers. I also mentioned another foreign company type case, which was Vietnam Beverage, $860,000 North Korean sanctions violations. And over a 2-year period, the Vietnam Beverage subsidiaries had 26 contracts to export beer and spirits to 2 North Korean companies. Pricing was done in US dollars, and payments were made in US dollars. And the senior managers at Vietnam Beverage reviewed and approved these contracts. What happened was then there was a restructuring of the company, and new management in 2019 discovered the North Korean transactions, and they self-disclosed. And Vietnam Beverage established remedial measures as well. But again, here we got a Vietnam company selling into North Korea, but using US dollars, which brings you back again into US jurisdiction. Now, we also had American Life Insurance, which violated Iran sanctions. And what's interesting here is watch the activities of the sale agent here. And when you get a bad actor who wants to have deals go through, they're going to, and really dedicated to that, they're going to do it. So first we had American Life Insurance ended up paying $178,000 for the Iran sanctions violations. They sold insurance policies and then processed claims for 3 UAE entities. Again, notice the connection between UAE and the government of Iran, and 3 UAE entities owned or controlled by the government of Iran. And so again, failure to get beneficial ownership information or even to recognize that you're looking at a state-owned enterprise. So the sales agent submitted these application for, and the sales agent's application was rejected. The sales agent then resubmitted the rejected application, by using a third-party administrator, and the sales agent produced false ownership documentation, and it went through. The same sales agent sold policies to 2 UAE schools that were linked by ownership to the government of Iran. Payments were rejected, and what did the sales agent do? He goes and gets cash. And the sales agent arranged for cash payments and collected the cash. So the insurance company voluntarily self-disclosed and cooperated, and they included new onboarding processes and training revisions. But notice in this case, OFAC even cited, if you have rejected applications or rejected a transaction, be careful, look for, and have a control in place to make sure if it's resubmitted that you provide appropriate scrutiny to it. Well, we also had our first individual case of the year, and this was a large one, $1.1 million against one individual. And it was a complex scheme for 75 violations of the Iran sanctions program. For over a 3-year period, this individual was involved in the purchase, renovation, and operation of a hotel on the Caspian Sea in Iran. And the financing of this was done in a really interesting way. First, the individual sold real estate in Iran and then reinvested the proceeds into the hotel. That's pretty straightforward. And second, however, the individual transferred funds using an informal value transfer system facilitated by a Canadian money services business. So what would happen is they would ask somebody to transfer money, let's say in Iran. They would contact that person and say, can you transfer some money from yourself from your own funds or from your own business funds to this business account, all right? And then the Canadian Money Service business would reimburse that person who was otherwise unknown directly to individual number one. It's called an informal value transfer system. It's very, very hard to detect in terms of, because it's you have two legs, but the two legs don't connect, at least without a telephone call or an arrangement of some sort. And the individual concealed lots of these transactions by, number one, not listing a purpose. Memo lines were left blank, reduced transaction amounts, and the message here again is OFAC will prosecute individuals. This was a well-heeled individual who clearly knew what they were doing and circumventing whatever. What happened to I got a question on the last one. Great question. What happened to that good old sales agent? He got a bonus? No, the sales agent was fired. And that was part of their remediation, was getting rid of him. But good question. Thanks for the reminder on that. Okay, so individuals on the hook. Notice the informal value transfer system. Well, this is actually my favorite case because it's just unbelievable in the scope. Unbelievable in the scope. AOTech, a German company, pays $14 million, $14.55 million for one violation. Now, it happens to be a pretty big violation. AOTech attempted to dismantle and then sell an Australian polypropylene plant to Iran. And this scheme is one of the most audacious, unbelievable schemes. And it made me think how much time people would put into a criminal scheme for what kind of benefit? What kind of benefit? So the Australian company hired a US company to broker the resale of a decommissioned polypropylene plant in Australia. The US company entered into an agreement with AOTech, the German company, to sell the plant for $9.7 million. And then they included sanctions compliance provisions. Obviously, they had good lawyers, whatever. But AOTech said falsely that the plant was to be operated in Turkey. And they even executed an end user certificate confirming it was going to Turkey. And this just shows you what happens when you don't audit or verify even your end user certificates. Because at the same time, the German company was conspiring with its Iran subsidiary and Petro-Iranian Downstream Industries Development Company, a sanctioned entity, to move the entire plant to Iran, not to Turkey. 2 days after they signed the sales agreement with the US company, AOTech, unbeknownst to the broker, enters into an agreement to resell the plant to the Iranian company and transport it to Iran, which is unbelievable to me. So you dismantle an entire manufacturing plant, and imagine all the paperwork now that has to be done, shipping documents, whatnot, to make sure you're not detected. In other words, to have your false location. And 2 days after signing the sale agreement, like I mentioned, this happened. And then AOTech began dismantling the plant. And for 2 years, they exported it in parts from Australia to Iran. And they misrepresented that the plant was to be rebuilt in Turkey and submitted false documentation. And the US company got wind of this. There was an anonymous complaint where they sent the US broker the copy of the offending sales agreement with the Iranian company. And what happened? Well, the US company conducted supposedly a thorough review and then said, no, it looks like everything's okay because of all the false documentation. But how much will a criminal conduct How much conduct will they engage in, and is it worth it in the end? Which is a really interesting question. Um, uh, anyway, so that's AOTech, and to me, it's just an amazing case in terms of think of how much shipping, bills of lading, everything that was false in connection with shipping the parts of a polypropylene plant. Got a good question here. Why no jail time for the individual? Going back to individual number one, that's a good question. That's a good question. And whether or not they're under DOJ scrutiny, I don't think the individual's criminal lawyer would let them sign this deal if DOJ had a case open on them. At least I wouldn't recommend that. And why not name the individual? I agree with you as well. You know, the SEC names individuals who violate securities laws, and why not name the individual who violates sanctions laws? I don't see any difference in that. And why not? We see civil enforcement matters involving people, individuals all the time. So, two good points. And this would be one way to really drive home the message. I agree with that comment as well. Thanks for that. Okay. Well, the ironic case of the year was definitely C.H. Robinson. Some of my clients have used C.H. Robinson for advice on trade compliance programs. And guess what? C.H. Robinson, through acquisitions and poor integration processes, ended up uh, incurring a number of violations of the Iran and Cuban sanctions programs. C.H. Robinson is a logistics company, and they failed to integrate the acquired companies into their operating systems and their sanctions data processes or their sanctions screening capabilities. So, for example, these are all acquired companies, and what happened was they transported in China, they transported a shipment from China to Turkey with a stop in Iran. In their space cargo group in Spain, they sent spare parts for textile machinery from Spain to Iran. In Canada, following an acquisition, they had 71 shipments to Canada of goods of Iranian or Cuban origin, valued at 448,000. Australia, following an acquisition, 8 instances where a customs broker imported into Australia Iranian origin goods from Germany, Spain, Singapore, and Iran. And finally, we have Peru, where an employee facilitated an export from Peru to Iran for $74,000 in value. So, but 2022, their export compliance team, and kudos to them, discovered the violations during regular sampling audits. Great to hear that. It's something that everybody should be doing at this point, which is sample audits. In other words, sample your audits on third party transactions in particular, where you can verify where these goods were shipped and where does it match the end user certificate if you have it, and what about the paperwork. We had another individual case, which was, and again, the individual is not named, but the first enforcement action of the Magnitsky sanctions, which are very popular, very famous. And here, this is an individual who paid $45,000 for 6 violations over a 6-month period. The individual did 6 payments with a blocked individual who was in the UAE, I believe. And the individual was sanctioned with respect to the Russia sanctions program, and nonetheless went ahead. Um, uh, Going back, got a great question from the last one here. Was any action taken against the Canadian company And we have not seen that. And I suspect they cooperated and maybe got themselves a deal that OFAC told the Canadian authority as well. Interesting, though. Great question. Thanks for that. So, anyways, we were talking about the individual. He was a secretary and treasurer of a company, and the CEO, who was the only other employee, and the CEO was added to the SDN list. And the person didn't even consider this and just kept making transactions involving the CEO. And you would think that this person would have been sensitive to it. And what did OFAC drove home, or at least tried to drive home, the point about uh, 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 drove home the point about gatekeepers and professionals' responsibility to exercise reasonable care. And they want to make sure that individuals who are involved with financial or legal functions, uh, put them at a higher risk of, allowing access by blocked persons. So they really wanted to send a message, which was, okay, folks, you got to be really careful here. And this individual ended up paying the price for that. Cordoba Music. Cordoba Music is another reminder that a lack of knowledge, that a incorrect belief, is not a defense in an OFAC case. So in February of 2023, Cordoba was acquired, and on April 2023, the new sales team forwarded it to the new parent a draft distribution agreement with an Iranian distributor to sell guitars in Iran. The new parent's leadership then said, hey, shut this down. They discovered this. But this had been going on for several months by the new team, and the new team thought it was okay. And obviously, they weren't trained. Obviously, they weren't integrated, and they weren't made aware of the parent company's policies. And they knew that the products were destined for Iran, but they didn't know that exports to Iran violated the U.S. sanctions. And this is just a glaring absence of training and integration. 9 shipments were sent in Cordoba, obviously, besides getting negative reputational publicity, also got hit with a $41,000 fine as well. So this is just another reminder, lack of knowledge, another integration type case. The last case of the year was SkyGeek. SkyGeek, interestingly enough, these were also violations of the Russia's aerospace and technology sanctions. And when they attempted to refund to two companies that had been subsequently designated as SDNs in the UAE, they didn't rerun the screening. And in the interim time period between the time of the initial transaction and the refund, these two companies had been placed on the SDN list as part of the Russia sanctions. And so when you refund or when you do a subsequent transaction, it means that once cleared, you got to keep screening them just in case the situation has changed. Now, just a reminder on the Commerce Department. Commerce Department has been ramping up enforcement if you're following those. We had 15 criminal cases, which I included in the 70 that DOJ brought. DOJ is the only one who can bring criminal cases. In 15 criminal cases involving China, Russia, and Iran, this related to the transfer of sensitive information. It's done by the Disruptive Technology Strike Force. The largest administrative penalty was on a pretty well-known company, TE Connectivity, and it had a voluntary disclosure of the illegal export of low-level items to parties tied to the People's Republic of China military electronics programs. Please be mindful of that area in the future because we're going to see more and more designations or more and more tighter restrictions on Chinese military products. In other words, products that could be used by the Chinese for military purposes. We also had a $3.3 million penalty on a California company for exporting controlled items to Russia. We had 4 anti-boycott prosecutions, the largest in a long time, and $400,000 in penalties. But anti-boycott violations should be part of your trade compliance policy, and we're seeing sort of a more robust enforcement in that area as well. So let's talk about next year. What are going to be the new administration priorities and what can we look forward to? Well, the number one and biggest issue is tariffs. Tariffs, tariffs, and tariffs. As promised, we may see a universal minimum rate of 10 to 20% on all imports, targeting the EU, and 60% on China imports. That's what they're promising. And you have to look at your specific products and the tariff authority, but these are really going to be a shock. And when this happens, we're going to have evasion, circumvention risks, people trying to circumvent the tariff requirements, looking for alternative ways to bring products into the United States, be it through, let's say, Mexico, Canada, or whatever. There's going to be attempts to try to take care or try to circumvent these tariffs. So you really need to look at that. Got a great question before we go on. Question about OFAC's extension of the statute of limitations from 5 to 10 years. Any implications for the scope of due diligence, for example, for M&A? Great question. That was a big deal. These and the record-keeping requirements for OFAC are now 10 years. We also have civil enforcement that can go back 10 years on M&A acquisitions. Now, is OFAC likely to go back between and say, let's look at your 5 to 10 year ago acquisitions? I don't think so. However, now going forward, you should look back 10 years to see if you're buying a violation. Criminal, you can't retroactively extend the statute of limitations from 5 to 10, but going forward, it could be cases could be prosecuted with a 10-year statute of limitations. So that's an interesting, great question. Thank you so much for that. Really important change in record-keeping requirements and liability in general with regard to acquisitions. But in general, 10 years now. And that's to give them more time they run up against the statute of limitations often in their investigations. We've also seen tailored, we're also going to see, let's go back to the future here, tailored tariffs against companies that move manufacturing outside the US. In particular, if they move to Mexico, there's promises of tariffs that could be designated as well. So there's circumvention and compliance risks. We have aggressive China tariffs that are going to occur and export controls. And Canada and Mexico are on tap. Obviously, we've seen the beginning of that as well. This is absolutely interesting in terms of what's next. We're going to see, I think, a relaxation. Trump, the president has promised, or president to be sworn in, has promised to end the Ukraine-Russia war. I don't think that the U.S. will just turn around and lift all the sanctions right away. I think what you're going to see is a gradual lifting of sanctions, which will take time. And the new administration is obviously going to leverage something for lifting for the concessions. I think you'll see 12 to 18 months to lift the sanctions. At the same time, you're going to see ramping up of Iran and China. So Russia sanctions may start to come down, and that's where you're probably going to go. Now, a couple comments that came in. One, OFAC violations seem to be smaller than FCPA violations. Would you agree that smaller companies under 500 million in turnover need to be more vigilant about OFAC? Absolutely. Um, the smaller companies are not getting hit with FCPA investigations so much. If they do, it's usually going to be an SEC case, not necessarily DOJ. And I think if as this trend occurs, sanctions is going to be a bigger risk, particularly with the possibility of criminal prosecutions of companies akin to FCPA. But a great comment. Another comment, what if manufacturing for US companies is already in Mexico? In other words, not moving there. Well, I don't think that is going to fall within the new administration. Great question, great comment, because a lot of companies already have Mexican operations. I think it's when they see a loss of jobs in the United States and the movement of manufacturing facilities outside of the United States. That's, I think, where you're going to get those issues. Another question, or another comment. Do you see possibly a change to the origin definition moving from country of manufacture of the product like Mexico to a country that owns the manufacturer, China? That's a really good question, and I do see changes coming in that way. We have to really be careful to watch the BIS, EAR regulations, because we are already seeing the beginnings of what I think is going to be a tightening in China, and they're changing definitions, and they have already changed definitions in the last 4 years with regard to the product rule, the resale product rule, and all of that, and definitions that are used in that. For example, the Department of Defense just listed Costco shipping as a Chinese military entity. Well, a lot of companies use Costco shipping because it's one of the biggest transporters in the world. And now there's a risk that they may fall eventually under some definition linking them to Chinese military. And for that reason, that could have serious implications for anybody that does business with Costco shipping as well. Um, uh, Another question that came up was, do you think the Biosecure Act will be enacted? And if yes, in its current form, I don't know I don't know enough about that with regard to how far down the value chain or the supply chain that will go. But I think any legislation could end up being not necessarily uh, being enacted, but it could influence some of the regulators to do their own regulatory solutions. So that'll be something we should watch out for as well. Like I mentioned, we're going to see a renewed focus on Iran conduct and sanctions enforcement. Remember, Iran and Cuba and Russia extend to all your subsidiaries that you own or control. Those are the most sort of aggressive sanctions programs, and we're going to see even more use of secondary sanctions where people are going to be designated for transactions with SDNs, but they're foreign companies. And we've seen more of that, including the banks. So we're going to see aggressive enforcement against U.S. Subsidiaries. And we don't know what the EU is going to do. And that's going to be interesting in terms of Iran. The big squeeze on China is obvious. It's coming. We've already seen a little bit of it on advanced computing, semiconductors, on chips, quantum computing, advanced energy technologies, all dual use technologies with military applications. This is going to be the fighting area. CFIUS reviews are going to increase, and we're also going to see more outbound investment regulation, which has been promised for a long time. So we're going to see that. I've seen a lot more of the Forced Labor Prevention Act enforcement where people have had goods coming from certain regions or coming from China blocked. Marco Rubio, the senator, was the sponsor of this legislation and is going to be the head of the State Department. So you're going to see more and more enforcement here. Get your paperwork, get your audits, get your documentation in line if you can fall within that. And China military, like I mentioned, Chinese military uses are going to become more and more prohibited. So sensitive industries or operating in China means stricter enforcement. So be careful, plan for this because it's absolutely going to happen in terms of that. Just a little bit of a pitch for us. Thanks, everybody. We are here for practical solutions. We're here to help you. Again, if you need a set of the slides, please let me run our perennial poll so that we can, if anybody needs any particular help in particular in this area, we've been doing a lot of export control work, a lot of sanctions compliance. Don't forget our YouTube channel. I'll post this on the YouTube channel at some point with the FCPA year in review as well. Again, if you want a copy of the slides, if you couldn't get them, give me an email, mvolkov@volkovlaw.com. Please take a look at this. Is not as comprehensive, not as hard as anti-corruption enforcement and compliance. These are more targeted programs, and you can get at these. I'm not saying it's super easy, but I just would urge you to take another look at this and try to get to this issue as quickly as you can, because it's coming, and we're going to start to see DOJ as well getting into it. So, this is something we've got to be really careful about. So, thanks everybody. Stay out of trouble, but be good, and we'll talk to you soon. We'll have some more webinars coming up.